Welcome back to this course on copyright and related rights law. In a few sessions, starting today, we will be focusing on understanding the scope of bundle of rights and its nature within section 14, which talks about copyright. We had seen in the last session that although copyright as a term is used in the singular sense, the rights that are provided to a copyright holder are in fact plural in nature. Today's session will focus on two specific types of copyright: the reproduction right and issuance of copies. A connected topic with respect to issuance of copies, which is parallel importation, is something that we will also explore today. Let us understand the basic meaning of reproduction. Reproduction means the action or process of copying something. In the image, you can see a person using a photocopy machine. Whenever we think about making a copy, one of the first things that comes to our mind is possibly a photocopy machine, like a Xerox machine. Reproduction right forms the core of copyright, as within the very term copyright is the usage of the word copy. In terms of the fencing that we had discussed, copyright law provides to the right holder unauthorized copying forms the core of what the copyright holder has the right to guard against. Under section 14, we can see in terms of any kind of importance that we can give to the listing of these bundle of rights, you will see that the reproduction right falls at the very top. It is the first copyright that is expressed under section 14. You can see in the meaning of section 14, where copyright is defined, it says that for the purposes of this act, copyright means the exclusive right, subject to the provisions of this act, to do or authorize the doing of any of the following acts in respect of a work or any substantial part thereof, namely, in the case of a literary, dramatic, or musical work, not being a computer program, to reproduce the work in any material form, including the storing of it in any medium by electronic means. What we can understand is that reproduction, which is to create, as has been stated under section 14, an act of copying where it is in a material form. It could be in a physical form. Imagine a book. A book is in a physical form, in other words, a material form. But this provision also talks about storing of, say for example, a literary work in a medium by electronic means, meaning thereby that a digital copy would also constitute reproduction. This scope of reproduction, therefore, is that it not only restricts itself to physical forms, but also extends to digital forms. In this particular provision, we have seen that the reproduction right has been spoken of with respect to literary works, dramatic works, and musical works. Let us see what other works to which reproduction right is made applicable. With respect to computer programs as well, it is stated that the reproduction right, just as it has been provided within 14A with respect to other literary works, will be applicable. Why then is computer program provided as a different set? Because there are certain peculiarities with the commercial utilization of computer program, such as the right to rental, which we will be concerning in a separate session later. But as you can see, a computer program like the source code is something which is a literary work. We have understood that very clearly. And this is also capable of being reproduced. With respect to artistic works as well, the right of reproduction is present under section 14, but the wordings are peculiar to the nature of artistic work. Let us understand what this provision then says. It says, in the case of an artistic work, to reproduce the work in any material form, including the storing of it in any medium by electronic or other means, or depiction in 3 dimensions of a 2-dimensional work, or depiction in 2 dimensions of a 3-dimensional work. So up until the first representation, it is similar to our understanding with respect to computer programs and other literary works or musical works or dramatic works. But let us try and understand what is meant by reproduction in terms of 2 dimensions and 3 dimensions. What is meant by a 2-dimensional artistic work? 2-dimensional means having or appearing to have length and breadth, but no depth. 3-dimensional means having or appearing to have length, breadth, and depth. What we draw on a paper, say for example, if we draw a triangle on a paper, what we have done is effectively made a 2-dimensional representation. But a prism, for example, a solid object, would be a 3-dimensional form. When you take a look at this particular image, which is essentially a sticker on which there is a pattern, what do you think this is? Is this 2-dimensional or 3-dimensional? The fact that art is not restricted to only paintings of abstract considerations, but can also extend to technical specifications, technical drawings. After all, what does an architect make if not a technical drawing? We had understood this in a lot of detail when we were considering the meaning of artistic in artistic work. Because art is not limited to two-dimensional forms, reproductions can effectively be in a separate dimensional format. But because a dimensional shift could possibly be with the purpose of achieving a functional consideration, which copyright cannot protect, under Section 52 of the Indian Copyright Act, which talks about certain acts which will not amount to infringement of copyright, we find that there is a specific provision which says the making of a three-dimensional object from a two-dimensional artistic work, such as a technical drawing, for the purposes of industrial application of any purely functional part of a useful device. What we understand is that where function is wedded to the expression, and the purpose of such a representation in three-dimensional form is in fact utilitarian in nature, then such a reproduction would not be considered as infringement. Please remember this. I have referred this particular exception here only because it is very specific to this provision of reproduction. Otherwise, exceptions to copyright is something which we are yet to explore in much detail. Having understood the foundations of reproductions, let us now move to understand issuance of copies. The background to issuance of copies, let us look at and recall the doctrine of first sale understanding, which we had explored in session 38. Session 38, you would recall, was a discussion on resale royalty right or resale share right. We had discussed that upon legitimate sale of a unit in which copyright is subsisting, as per the doctrine of first sale, the copyright holder can no longer control the further distribution of that unit. With that background in mind, let us take a look at the right of issuance of copies. The same provision under section 14, I am not reading the main provision again. You can just look at section 14A subclause 2, which says the copyright to issue copies of the work to the public, not being copies already in circulation. The same provision is applicable for computer programs and artistic works. In terms of an example that we can consider, let us think about books. Since 14A talks about literary works, issuance of copies would mean that copies of books and the issuance of these copies is within the exclusive control of the copyright holder. There is an explanation to section 14 which says that for the purposes of this section, a copy which has been sold once shall be deemed to be a copy already in circulation. What we then understand is that the copyright holder, once he has engaged in the sale of a copy, since we are considering books, since a unit book has been sold, now that unit is in circulation, and therefore under section 14, the copyright holder can no longer exert his issuance of copies right. In other words, any reissue of that unit is out of the copyright holder's control. What this also should be considered to be is an isolated loss of control. This is a very specific limitation which has been carved out specifically with respect to issuance of copies. Always remember that just because the copyright holder has lost the control over reissuance of that particular unit, he has not still lost other aspects of copyright such as reproduction. Meaning thereby, just because a person has bought a copy of a book from the shop does not mean that he can now engage in reproductions. I hope this basic foundation is something that is clear. Let us now move to a connected topic with respect to issuance of copies, which is parallel importation. Let us consider that the sale which has happened in India. Then, as per the application of section 14 and its explanation, the sale of that unit and whoever has purchased that particular unit is now free to reissue that particular unit within the territory of India. But what if a unit was bought in some other country? After all, is it not that the copyright holder will wish to exert his copyright in other parts of the world as well? Would his books only be restricted to India? Will they not be sold in other parts of the world? If it is indeed sold in some other part of the world, then can such books be brought back to India and sold in India? Consider that the same book which has copyright in India is also having copyright in UK. Say the book has been bought in UK through the legitimate distributor of the copyright holder, then can such book be brought to India and sold in India? Would section 14 also apply to a unit which has been bought in a foreign state? parallel import is defined by the World Trade Organization as when a product made legally, that is not pirated, abroad is imported without the permission of the intellectual property right holder. Some countries allow this, others do not. Let us understand that the World Trade Organization, within one of its constituent agreements, which is the TRIPS agreement, or the agreement on trade related aspects of intellectual property rights, an agreement we have covered in passing in previous sessions as well, provides a discretion to member states to adopt a type of exhaustion, as it is referred to, which can allow for parallel importation to take place, which explains the last portion of this particular definition, which says that some countries allow this, others do not. So if you look specifically to Article 6 of this agreement, you will find this discretion. On the nature of a parallel import, you can see that there is legitimacy to the purchase, making it a legal purchase, and then it is brought into another country without the permission of the intellectual property holder. Therefore, this book, which has been bought in the UK, is being brought into India without the permission of the copyright holder. Now, in terms of whether there is something like a right of importation under section 14, we can see that under section 14 there is no right to import. Importation, therefore, does not prima facie appear to be something that the copyright holder is controlling. But as we can see under section 14, section 14 reads, for the purposes of this act, copyright means the exclusive right subject to the provisions of this act, where it says that this provision is subject to other provisions of the act. We must look at other provisions which are affecting this particular type of importation. So just because there is no specific right to importation provided in section 14 does not mean that there isn't any such action which can be taken by the copyright holder against importations without his authorization. Let us consider that the Copyright Act of India is only applicable in its operation to the territory of India, meaning that the issuance of copies right, which has been granted to authors under section 14, is only limited to the territory of India. In terms of what a copy which is in circulation will mean, is that with respect to those copies which have been issued by the copyright holder or through his legitimate distributor, only those copies will be considered as copies in circulation. In other words, an issuance of copy that has happened in some other part of the world is not an operation of issuance of copies under section 14. In that context, now let us understand what another provision is saying with respect to importation. Section 2 clause M of the Copyright Act, which is defining what an infringing copy is. It is saying, if such reproduction, copy or sound recording is made or imported in contravention of the provisions of this Act. Therefore, under the framework of the Copyright Act, importations can be in contravention of the provisions of the Indian Copyright Act, despite the fact that Section 14 does not provide explicitly for a right of importation. We can see that under Section 51 of the Copyright Act, which is talking specifically about infringing acts, it is saying that copyright in a work shall be deemed to be infringed when any person imports into India any infringing copies of the work. In its proviso, it says that nothing in subclause 4 shall apply to the import of one copy of any work for the private and domestic use of the importer. It often happens that when we travel abroad, we purchase books from airports or from a distributor within the territory of a foreign state, and we bring them back to India. Because the purpose is private and domestic use, this will not be covered as infringement. But where this is not the purpose, then depending on also the quantum which has been prescribed under 51 as a strict one copy, it is potentially infringing. What we must understand is that even though, like I said, Section 14 does not prescribe a right to importation as a copyright specifically, other provisions of the Act, such as Section 2 Clause M and Section 51, are suggesting that importation can in fact be in contravention of the provisions of the Copyright Act. Let us then understand that this is an application of the right of issuance of copies. That a copy which has been bought in the UK was issued in the UK by the copyright holder operating under the issuance of copies right in the UK. That copy was not issued in India under Section 14. Therefore, unless there is an explicit provision within the Indian Copyright Act that is allowing for an exception against the application of issuance of copies right, we cannot say that parallel importation is something that is allowed. An insertion that was suggested by the Copyright Amendment Bill 2010 to Section 2 Clause M was, provided that a copy of a work published in any country outside India, with the permission of the author of the work, and imported from that country into India, shall not be deemed to be an infringing copy. This particular proviso was not inserted into the 2012 amendment, and therefore, as of this current time as well, does not form part of the Copyright Act. But let us examine this proviso. It is simply saying that where legitimate copies are being brought to India, the legitimacy here is in terms of the legitimacy of sale that has happened in a foreign country. What this proviso would have said then is that any such books, for example, that are being brought back to India, these books will not be considered as infringing copies. But the only safeguard that such a proviso would have offered is that it would have made these copies to be non-infringing. It would not have allowed for an exception against issuance of copies. Therefore, in summarizing, we can say that the issuance of copies right in India is a right which is operating within the territory of India, a copy which has been purchased in a foreign country. When it is brought into India, it will be subject to other provisions of the Indian Copyright Act, and such importations, when they are being used for the purpose of issuance, will strike against the issuance of copies right. I hope this is understood. In the next session, we are going to take a look at another copyright, which is the right of adaptation. Thank you for joining me. See you all in the next session. Thank you.